Members, good morning. We have a quorum. So I call to order the meeting of the panel on development. Item 1. Information paper issued since the last meeting. The Secretariat has not issued any paper since the last meeting. So on to the next item. Item 2. Proposed amendments to the Buildings Ordinance, Cap 1, 2, 3. Let's invite the administration to come in. Members, if you want to speak, please press the request to speak button.
As
the government officials are coming in, let me read out the names of members. Mr. Lau Kuo-fan, Dr. Professor Chow Man Kwong, Mr. Stanley Ng, Ms. Chen Yut-ming, Mr. Chan Hok-fong, Mr. Andrew Lam, Mr. Bill Tang, Dr. Wendy Hong, Mr. Edward Lau, Mrs. Regina Ip, and Mr. Tony J. And we are joined by the administration. You will find the names on the attendance list. I'm not going to read them out again. So let me welcome Secretary for Development, Ms. Bernadette Lin, and her team to our meeting. She will say a few words, and then there'll be a PowerPoint presentation. Thank you. Now, just for background, in the 2023 policy address, the government proposed to review the Buildings Ordinance, Cap 123. So we conducted a systemic review last year. Today, we'd like to consult members on the proposed legislative amendments. And starting from the end of this month, we will roll out a 2-month public consultation on our proposal. We'll also be seeking views from different stakeholder groups. Following that, we will commence work on drafting the bill. Our target is to table the amendment bill in the first half of 2026 into the Legislative Council. I want to spell out the time frame and specifically the timetable because this proposal will surely attract diverse views in the community. So let me first reassure everybody that we're not going to hastily roll out anything in the coming few months. We need to first start with public consultation. Now, I think this is the first opportunity we discuss this proposal at the panel. And after this discussion and after the consultation, we may refine our proposal subject to the views. And then we will report to the LegCo again, and that is why we won't table the bill until the first half of 2026. Now, after its enactment in 1955, there have been no major amendments to the Buildings Ordinance, except the introduction of the mandatory building and window inspection schemes in 2012. We believe there is a practical need to take a targeted approach to amend the ordinance to address various concerns from the community. For example, concrete spalling from the external walls of buildings and unauthorized building works of the Red Peninsula revealed last year after the torrential rain. There are also other enforcement issues in relation to unauthorized building works that relate to the day-to-day living of the people, and this is causing public concern. The other point is safety incidents at construction sites. And after the occurrence of these incidents, how do we make sure that the contractors and building professionals will be taken to account? So these are matters of public concern. Our paper sets out the various proposals. They are formulated on the 4 major guiding principles. First, it is the owner's primary responsibility to maintain and repair the properties. The government will step in if necessary, but after all, it's the owner who is primarily responsible for maintenance and repair. The second guiding principle is that we support owners in complying with statutory orders and notices, in particular the necessary building inspection and maintenance notices. Adopting a carrot and stick, we also strike a balance between lenient and stringent enforcement to make sure that owners will fulfill their responsibilities. So, between the lenient and stringent enforcement approach, we'll also adjust the enforcement latitude, having regard to the type and nature of contravention. For low-risk cases that lead to less serious consequences, we tend to be more lenient, and vice versa. The fourth guiding principle is that the principles and objectives should be clear. That means we need to articulate our policy well, and in terms of enforcement, we will be pragmatic. I'd like to invite members to read through our proposals. We're going to increase the level of fines. We're going to increase penalties. There will be new offenses and new mechanisms as well. We will also lower the prosecution threshold. Now we will rationalize the policy for handling unauthorized building works, as I just explained. And the third major proposal is to enhance building safety. Now, without further ado, I will invite Ms. Jenny Choi, Deputy Secretary for Development, to give a presentation. Yes, please be succinct, as we have a lot of members waiting to ask questions. I was going to continue Mrs. Regina Ip, Mr. Tony Jen, Mr. Kenneth Lau, Mr. Longman Kwong, Mr. Ben Chen, Mr. Rin Kwong, and Mr. Frankie Yik. These members will speak after Mrs. Regina Ip. Right, you may begin. Thank you, Chairman. Now, I suppose members have read thoroughly our paper, so I will jump to the proposals section. There are three major proposals. The first one is expedite building maintenance and repair. As the Secretary mentioned, we're going to take a carrot and stick approach. That means we will support owners through the Operation Building Bright 2.0. Starting from this year, we'll step up monitoring and procurement support for owners and owners' corporations. Now, whenever we come across dilapidated old buildings that may pose a safety risk, the government will step in. For example, we regularized the external wall inspection scheme this year by using drones to inspect the external walls of high-risk buildings. We introduced the mandatory building and inspection schemes in 2012. However, the compliance rates are low, especially in respect of the common parts. And experience shows that it takes a long time to prosecute a case. The sentences are not deterrent enough. So there is room for improvement. Now, for failing to comply with the MBIS notices, we propose to increase the fixed penalty to $6,000 to encourage compliance by owners. Now, in relation to mandatory window inspection notices, the non-compliance on an owner will only attract $1,500. Will raise his penalty to $3,000. Now, for failure to comply with statutory notices and orders, these cases may often involve external walls or objects falling from external walls and their projections, and these could lead to property damage or personal injury. We want to hammer home the message that it is important for owners to maintain and repair the buildings properly, or else there would be dire consequences. So we propose to introduce a new offense with a fine of $300,000 and an imprisonment for 1 year. Meanwhile, we will continue to implement other measures to better support owners in complying with notices and orders. The next specific proposal is to rationalize the policy for handling unauthorized building works. Under the current mechanism, works that are not submitted to and have obtained prior approval from the Buildings Department or carried out in accordance with the simplified requirements of the minor works control system, unless they fall under the exempted categories, they will be regarded as unauthorized building works. They will be dealt with two ways. First, the Buildings Department will issue removal orders for knowingly carrying out unauthorized building works, regardless of the level of risk and scale. Now, this entails a very large number of unauthorized building works. The problem is this will thin out resources available for the department to go after the more serious cases. And for the more serious cases, the whole mechanism may not be deterrent enough because of the high prosecution threshold and the time needed to gather evidence to initiate prosecution. So we will rationalize the policy for handling UBWs. In other words, we will take a two-tier approach. For minor works relating to people's daily lives that have low risk levels, we want to take a pragmatic approach that is people-oriented. That is, we will include more items as designated exempted works or DEW items, so that public will find it easier to carry out these DEW or designated exempted works without BD's approval. We also have the validation schemes. At the moment, professionals will be engaged for the purpose of validation. If the works are deemed not to be not to impose any safety risk, these UBWs may be kept. Now let me give you some examples. You can see from these slides that we want to add items to DEW mechanism. These are currently minor works, and we will further relax the criteria to cover, for example, contractable awnings, supporting frames for air conditioners, Now the other point is we want to relax the size requirements in relation to DEWs. At the moment, they are quite stringent. We are going to relax the size requirement for drying racks, a supporting frame for air conditioners, so on and so forth. We're going to relax specifically the clearance level. We will also add more items of our minor works, such as projecting signboards. In terms of the dimensions, we're going to relax the requirements so that more can be included under the minor works control system. On enforcement, we will introduce a grace period for the first 3 years. That means no enforcement action will be taken, but after the lapse of the grace period for unvalidated minor works, we will take enforcement action, as well as the new building works. So for works not removed despite the issuance of a removal order, we will introduce a $10,000 fixed penalty. There will also be a new penalty for subsequent convictions, and that the fine will be doubled.
For serious UBWs, in other words, you're supposed to have submitted a plan to get approval from the BD before you can start work. Then for such UBWs, in terms of safeguarding public safety and in terms of being fair to everybody. They should not be tolerated. They should be eliminated. And therefore, in this direction, we are going to enhance the fines and we are going to lower the prosecution thresholds. Just now, we said that in order to prosecute a case, the BD has to prove that the owner has knowingly erected the structure without the approval of the BD. We are going to remove the word knowingly. So as long as there's reasonable suspicion on the part of the BD that such has happened, then the BD may initiate a prosecution. Of course, citizens may be worried because they are worried that they will be subject to prosecution. There will be many such cases, but in fact the law will provide for defenses. For very serious UBWs, will invite the court to consider the size of the UBW, the location of the property when it comes to sentencing, because it will have a huge difference on the impact of the value. So we hope that such can be reflected in the final sentencing. In addition, we would like to introduce a new offense. That is, after a specified period of time has elapsed after the enactment of the amended ordinance, and if you acquire a property and there is in existence a serious UBW, then the owner will be prosecuted, whether it was the owner that erected the UBW. So if somebody assists the owner in acquiring such a property knowingly, then this person will bear the same legal liability. He will be regarded as having done the same. And then for the appeal process, we're going to expedite it. Currently, for removal orders, owners will lodge an appeal so as to delay the process. So we're going to expedite the process. In the year 2012, we ended an administrative arrangement. 11 items of minor UBWs can be subject to an application procedure. We're going to restart it and would like to resume the administrative scheme. And in fact, all those arrangements will be in operation again. And thirdly, we would like to enhance the construction site safety in terms of disciplinary actions, dealing with renewal applications for registrations as well as prosecution. In terms of prosecution, we would like to enhance the penalties and would like to enhance the enforcement powers of the BD. There will be new offense. Well, currently, the BD cannot compel the contractor or relevant persons to come up for an interview. So that creates difficulties in collecting evidence. Now, in future, there will be new offense. If there is a refusal to attend an interview or if there's a refusal to submit records demanded, there will be an offense. And then the penalties will be enhanced. And we have made reference to the Occupational Safety and Health Ordinance. Now, I come to the area of registration and disciplinary action. Well, currently, when we have to deal with an application for renewal of registration, we cannot shorten the period, even though the contractor has to seek some improvements and no additional conditions can be imposed. So we would like to allow greater flexibilities to the BD in terms of this problem. And then the penalties under the disciplinary procedures will be given, and in fact the disciplinary board can impose more than one penalty. And then in terms of the laws, in terms of the operation, in terms of the administrative work, we would like to clearly define the roles and responsibilities of key personnel involved in the construction works so that they know clearly what is expected of them in terms of supervision, how often and how detailed. Well, I think I've covered the main points of our proposals. Thank you. Well, colleagues, we need to consider the other item on the agenda, and that would require approval. At the same time, I know that you are very interested in the current item, 4 minutes each, but I will be very strict about time management. When you are up to 3 minutes, I will sort of remind you so as to allow the public officers to give an answer. First of all, Mr. Everlau. Thank you, Chair. I support the proposed amendments to the Buildings Ordinance. In the 1950s, it was introduced. Other than in the year 2012, the MBIS and the MWIS were introduced. Other than that, we haven't had any major amendments, so it is the high time to do so. Well, spalling of external walls of dilapidated buildings have caused injuries, and serious UBWs were found in luxurious properties. So I agree with the departments and the bureaus. And then for the fixed penalty tickets, $3,000, $6,000, I'm sure they can have a stronger deterrent effect, and then there will be a higher compliance rate of the notices. $3,000, $6,000 are about right, because you get $3,000 fine for littering, and by failing to inspect your windows, there will be a potential hazard to yourselves as well as to others. So the fixed penalty ticket amount is about right. I want to comment on the policy aspects as well. Just now it is said that the fine will be dependent upon the location of the property, etc. I may not agree with you totally. Well, in terms of UBWs and irregularities, they should be treated the same. So we should look at the seriousness and the degree of hazards to determine the fine instead of the value of the property. I think it's a matter of principles. And then for prosecution, you are going to delete the word knowingly. Yes, I agree that by setting the threshold too high, it's easy for people to rebut the accusation, and then they can stay away from the long arms of the law, and then we can't really enforce the law. By deleting the word knowingly, I'm afraid genuine owners could genuinely did not know would be caught, or the owner has been advised by professionals that everything is fine. So you did say that there would be reasonable excuses or there will be defenses. Please elaborate. Can we sort of show a contract or whatsoever to prove our innocence? Otherwise, people would be falling. People will commit an offense unknowingly. Now, even if you can enhance the penalties, it is more important to be able to enforce the law, collection of evidence, and getting cooperation from the relevant persons. So would you elaborate on that so that you can collect your evidence more easily? In addition, by resuming the administrative scheme for the village houses is a good policy. Please brief the people involved again, because over 10 years have already elapsed and people can't recall what the details are like. Well, we need to abide by the 4-minute rule. Well, we are not actually saying that this will be incorporated into the law. That is considering the location of the property to consider the level of fine. We are merely saying that perhaps we should make some suggestions for the court to consider, but the member's point is noted. I can cite an example to illustrate the point of deleting the word knowingly. Currently, if we know that there is an additional floor on top of the building. And if you compare the aerial photos, then there is a suspicion on the part of the department that the owner is involved. But then usually the owner will say that I don't know about it. And it depends on how much evidence would be collected by the department. I think in future, prosecution can be started and ask to the owner to explain. Dr. Chow. It was almost 70 years ago that the ordinance was introduced without any major amendments. And then we have 9,000 buildings, and in future there will be 15,000 buildings that are very dilapidated. So we should look at the composition of the disciplinary boards. Now, many professionals have to abide by a number of ordinances, Cap 123 and Cap 344, which is the Building Management Ordinance. So for somebody to carry out the works, if they didn't go through the procedures or if they were too fast, then they will be caught by Cap 344. But then if they are too patient and if they try to abide by the rules step by step, then they will be caught by Cap 123 by failing to do so within the deadline. So I think when it comes to the enforcement of the law, you have to give full play to such factors. Well, in fact, owners and members of the executive committees of the owners' corporations are no longer interested in carrying on with their work because they're too worried. We don't want to have mass resignation of such chairmen and members of owners of corporations. For the 3 new buildings, we have got 3,100 at the end of the year. So what are the criteria for carrying out the default works? We have just amended Cap 572 concerning fire safety, and then you are going to carry out default works in relation to fire safety for such buildings. Can you not sort of coordinate among the departments? Otherwise, the OCs and small owners have to respond to different departments, and then it can cut down on the impact on the owners as well as cut down on the reduce the inconvenience. Well, regarding the worries on the part of the OCs, the owners, etc., as to the extent of the liability, we are aware of that. By enhancing the penalties, we are able to persuade the owners to organize themselves. Sometimes it's difficult to do anything on your own, but then by organizing a owners corporation, then they can cooperate and they can quickly put together their efforts to carry out the work. And if it is a matter of doing things in good faith, then individual owners don't have to bear any individual liability because the incorporated owners is a legal person. Of course, owners have been saying that the OCs may be very have been doing their best, but then individual owners are not cooperative. And in our proposal, we are saying that for uncooperative owners who block the work, then they will be prosecuted. There are buildings where the owners are not yet organized. We'd like to cooperate with the HAD, and then we will carry out more briefing sessions for them. For default works, I think the BD has carried out many more default works. Say, for example, we took the initiative to check the external walls. 40% plus of the cases were followed up by the default works of the BD. And then for joint efforts, we will do our work together with the FSD.
After Mr. Stanley Ng has spoken, I will draw a line. Altogether, 17 members would like to speak this morning. I may not even have time for myself because the next item is equally important in relation to the allocations to the Capital Works Reserve Fund. Right after Mr. Frankie Yik, we have Mr. Yao Wing Kit and Mr. Louis Long, altogether 18 members. Mr. Stanley Ng. Chairman, we welcome the government's proposed amendments to the Buildings Ordinance. Time is ripe to keep abreast with the times. These amendments will help owners. They will also help owners in fulfilling their responsibilities to ensure building safety. We fully support the government's guiding principles in the legislative amendments. But I think that the government is placing too much emphasis on increasing penalties to increase deterrence. The government doesn't seem to be interested in why the owners or owners' corporations are not complying with the orders and notices. Well, I don't think this matter is as simple as just raising penalties. More support should be given. For example, inspections should be carried out more frequently. Advice should be given to owners, especially elderly owners of 3-nil buildings or old and dilapidated buildings. More advice should be given to elderly households so that a more targeted approach can be taken to enhance building safety and building work safety. I'd like to turn to another point. In terms of the carrying out of works, you're going to propose amendments to improve the supervisory mechanism. For old buildings, not much space is available for the works. So for new buildings, the government should specify that areas be made available for building works for the purpose of, say, erecting scaffoldings or otherwise, so as to ensure compliance with the Buildings Ordinance. Secretary, we're going to step up support for owners as well. It's not just about raising penalties. If I could ask members to turn to paragraph 10D of the paper, we've set out ways to better support owners. For example, some owners would like to use the Smart Tender platform. The Smart Tender platform at the moment is not selective, and we consider extending the pre-qualification mechanism so that the owners will be able to choose the right contractors for them. And about the Operation Building Right 2.0, we needed unanimous agreement for owners to join the OBB. We're going to roll out the joint management of multiple buildings scheme, and we'll also consider whether we can extend or relax the eligibility criteria of Operation Building Rights. Now, for new buildings, to answer the member's question, we've already designated areas for building works, and we note members' comments. We will give it a thought. The last member to speak will be Mr. Louis Long. Next, Ms. Chen Yuming. Paragraph 19 of the paper refers to kickstarting the run-off reporting scheme for small village houses. Again, I want to declare, first of all, that I am a member of the Executive Committee of the Hung Yi Kok, and I welcome the reporting schemes relaunch. We have 27 homes in the new territories. So let me share with you how I feel about this. Each home comes with their unique history and characteristics. For Northern Metropolis and Santin Technopole, altogether they will touch on a dozen villages. They come with their unique history, and at the moment they've run out of space because of historic reasons. There are problems with drainage and storage, and there are also many complaints relating to unauthorized building works. Now, many residents have received removal orders from the buildings department, and they are concerned whether they'll be able to keep the village. So I hope that the department will keep an open mind. In Santin, many village houses are very small. The smallest one is just 115 square foot, and the majority of them are just 200 or 300 square feet. And we also need to set aside space for septic tank and other facilities. Now, unlike UBWs in urban areas, the small houses in the new territories are quite unique. And it is not pragmatic, given the manpower level, to tackle UBWs in the new territories relating to small houses. So I think it's pragmatic for the government to have regard to the actual situation and relaunch the administration scheme. This can also help ease tension between the government and the rural areas. Now, my questions are these. First, when will the reporting scheme be launched again? Second, I'd urge the government to visit the homes. The officers should set up liaison channels. And if need be, I will give whatever support I can. Secretary. Now, as to when we are going to relaunch the administrative scheme, let me say that this is an administrative measure, so we don't need to wait for passage of the bill. But let's just say that we should wait until the end of the public consultation period, after 2 months, so that we could gauge public views and see whether there is general support. I want to emphasize that all the eligibility criteria will remain the same. Now, some residents might be concerned in the past that they did not report their UBWs in time, and they'd like to see a relaunch of the scheme so that they have another opportunity to do so. Now, let me reassure members that we are not making UBWs legal. After reporting the UBWs to us, at least enforcement action won't be taken immediately. Now, after at least year 2030, we may consider taking enforcement action, but sufficient notices would be given. And the member also asked us to explain our policy to villagers. This is indeed what we intend to do, and we will not just explain to villagers, we will also explain to the public in the urban areas as well as the various professional institutes. Mr. Chan Hao-fong. Many owners and owners corporations have expressed concern after hearing about this. The OC members are concerned about the liabilities. They ask whether they should just quit. Especially, you're going to introduce a fixed penalty for certain offenses. Now, as you know, many OCs do not have the know-how to carry out building works. So they are willing, but they are not equipped with the necessary knowledge. Now, about compliance, you need to spell out exactly what it means. For example, some owners' corporations may have had numerous meetings already. So have they complied with the order? And about the latest offense and the $10,000 fine for UBWs, again, you need to give us the details, and you should also listen to views at the public consultation stage. Of course, you would advise any owner or OC to join the smart tender platform so as to carry out building maintenance as quickly as possible. But the problem is, this is not mandatory. This can be abused by some owners with ill intent. For example, recently we've heard about cases of deliberately not joining the smart tender platform. So can you make it compulsory for owners, corporations to join the smart tender platform to protect the interests of minority owners? This is something you need to mull over in your legislative amendment exercise. I think the smart tender platform is very crucial. You should make it mandatory. Now, for 3 new buildings, is there room for them to actively apply for the government to step in? I know that the government carries out default works, but it's not initiated by owners. Is it possible that if you have 70% or 80% support from owners, the government can then step in and carry out works under the default work mechanism? Now, my next point is the white list. We have a list of contractors, but what are the eligibility criteria? Are they contractors that have not run into trouble about finishing the works, or will the government provide a clear set of criteria to make sure that owners will not be cheated? Secretary. Owners corporations are concerned whether they will face prosecution if they don't carry out the orders in the works in the orders immediately. Last year, 2,700 buildings failed to comply with the orders or notices, but only some 200 buildings faced prosecution. Out of the 2,700 buildings that had not complied with the orders or notices. Now, for these buildings, for the remaining buildings, at least some sort of action had been taken. For example, they had engaged professionals, etc. So, and of course, we need to explain our approach to owners better for them to reassure them. But we also need to alert them about the possible consequences as well. They should not be too complacent. About the default works mechanism, it is true that this is not initiated by owners. Now, you propose allowing owners to do so subject to a certain percentage of consent from owners. But in such a scenario, the government will need to be involved in various works. So the government takes a discretionary approach. We consider, for example, whether there are mostly elderly owners and whether there are missing or untraceable owners. So it will be considered on a case-by-case basis. About the URA's white list, we considered whether the contractors have sufficient experience, whether they have carried out similar works before, and whether they have sufficient manpower. Next, Mr. Andrew Lam. Unauthorized building works should be handled under the Buildings Ordinance. I appreciate that there is a lot on the plate of the current term of government, and I appreciate that this government is committed. But because of the huge backlog, we do need to iron out the details, and that means the consultation period should be longer for the public to assimilate the information. This legislative amendment entails a major change. We need to accord priority to different matters. Now, I'm happy to learn that according to your presentation, your amendments will cover different issues. Now, in terms of priority, I think that safety should be given the top priority, especially public safety. And for various reasons, the government has all along adopted differential approaches to UBWs in the urban areas and the rural areas. Now, on this occasion, I'm finally seeing the same yardstick being applied. For example, in order to step up deterrence, we are going to draw a line after a specified date, and for new building works carried out after a certain date, stringent enforcement action will be taken. This is important in providing deterrence. And the administrative reporting scheme is, of course, also important in ensuring timely handling of the UBWs. On the level of penalties, I agree that the court should have regard to the value of the property, the locations, etc. Because from past experience, we learned that courts tended to mete out quite lenient sentences. And the government should lodge an appeal in the case of the sentences being too lenient. So there should be reference of some sort. Finally, apart from owners, I believe that professionals and contractors are equally responsible. In terms of building works or property transactions, professionals clearly have a role to play. These are competent professionals, but they also have a lot of responsibility in the process.
Secretary, I note the members' support for our major principles as well as his comments. Next, Mr. Bill Tang. Well, in relation to the tiered system for dealing with the UBWs, I think you have the consensus in the community that is they're going to impose more stringent enforcement on the serious cases, and then for the minor cases, you're going to tolerate them. Now, my comment on the tiered system, you may not agree with the wording that I'm going to adopt. Now, you say that in your paper that there will be consultation to gather more views. Now, currently, we have to erect solar panels or even some other small items to have wind power so as to conserve energy in our buildings. So will minor works cover erection of renewable energy devices? And then you will cover occupational safety and health as well. And you're going to align the levels of penalties with those in that piece of ordinance. I want to know whether the idea originated from the Labor Department or that you have discovered a loophole in the ordinance that is somebody should bear responsibility, and yet currently under the law we are not able to do anything about it. So please tell us as to why you started the amendment proposals. Secretary, we are going to expand the scope of the minor works so that you can have your minor works validated. We have cited examples in the paper. There is items that would possibly be covered. Just now the member wondered whether other items can be covered. Well, during the public consultation exercise, we'll have an open mind. You talked about the solar panels, member. But then it won't be easy because if you haven't got any approval and you have erected it, but then they're exposed to the elements. Hong Kong is subject to typhoons. Should they be tolerated? Could they be tolerated because they are of a substantial size? we have to consider the matter. And then you talked about site safety. If we are to prosecute the contractors or the relevant professionals, we're going to enhance the penalties. Well, in fact, we heard the voice of the community. And in fact, for the Labor Department, they have substantially increased their maximum penalties, right up to $10 million. But in the area of building ordinance, we haven't got the same. So we are trying to, or we have reviewed the similar offenses under different pieces of legislation, and we try to align them. So there's the rationale behind our proposals. Dr. Wendy Hong. Well, in fact, the BO will have a huge impact on the community. I welcome the move on the part of the administration. 2 questions on my part. First of all, MBIS as well as MWIS, their compliance rates are unsatisfactorily low. Now you're going to introduce a higher rate of the fixed penalty tickets. Now, even if the fine is $3,000, the landlord can offset the fine by increasing the range or from the range. So other than imposing a fine, are you going to register the offense with the land registry, that is creating an encumbrance so as to have a deterrent effect? And then for the serious UBWs, I think you're talking about the serious UBWs that have not been newly erected. They don't have any safety risks, and they're not visible from outside, and they're not affecting anybody outside of the property. And if the owner is willing to subject the UBW to regular inspection, if all the 3 conditions are met with, can a validation system be introduced, and then the owner can get approval by paying the premium. I think in this way, well, we can address the problem. But of course, I'm not talking about those UBWs that would have a public safety hazard. So what is your comment on my proposal? What are the pros and cons? Secretary. Let me answer the second one, and I defer the first one to my colleague. Well, the second question is important. Now, for large-scale UBWs, like a basement or an additional floor on the rooftop, if it is said that if it is found to be safe, let them pay for it so that the public coffers can have additional revenue. Can that be tolerated? We don't advise that. We don't want to go down such a route for 2 main reasons. First of all, we don't want our future generation to have the idea that you can pay for breaking the law. And then even if the UBW has been inspected by a professional, like an additional floor on the rooftop or a basement floor. Now, a professional may be able to inspect it with naked eyes and say that it is safe, but don't forget that at the time of construction, no building plan was submitted, and probably they didn't have any construction records. Well, in overseas experience, they might ask for the structure to be sort of taken down or sort of break up parts of the structure to check the safety. So by just having visual inspection, can we be assured of the safety? Therefore, for large-scale UBWs, owing to the above-mentioned reasons, we don't want to adopt such an approach. But then for minor works, we do allow professionals to carry out a simple validation process. Permanent Secretary, be brief, please. Well, our current proposal will not say that for non-compliance with MBIS and MWIS, there will be a difference in the level of fines. In fact, we have a new offense to be introduced. Now, if concrete spalling causes injuries to passers-by as a result of non-compliance with the notices, then there will be an offense and a penalty. I think to a certain extent, it has addressed the members' concern. Mr. Ebeler. Thank you, Chair. I support the proposals. It is the right time to start such a dialogue. I've been following up on a number of cases in Island East. Some owners said that 50, 60 years ago, they bought their properties. At that time, the developer has already added an additional floor or additional structures. If they are to demolish them, then they will have to live without a kitchen. Now, it is said that if you acquire a property after amending the ordinance, then you will be subject to the new fine, $2 million, etc., etc. For those acquired previously, then the penalty that you get will be to demolish the UBW. Is my understanding correct? That is, there will be a cut-off date depending on whether you get the property before or after the amendment. Secretary, let me explain it in this way. Well, for UBWs, they will be classified into two categories. First, if they can be regarded as minor works, then in future, whether you already have it now or whether you acquire it in the future and then you find that a supporting frame for an air conditioner hasn't been approved previously, then we say that within a certain period of time you need to join the validation scheme. Once validated, then you will be treated leniently, so to speak. But then for large-scale UBWs, whether the owner has already acquired a property with such, or whether he acquires a property in future, the government is not going to deal with it leniently. We will ask you to remove it. And if it can be established that the owner is involved to a certain extent, that the owner will be liable. Now, when we talk about cases that would be caught by the amended versions, we are saying that sometimes an owner may acquire property with a UBW on the rooftop, and the owner finds it very convenient. Now, we say that within a specified period of time, now, when you acquire property, you better get a professional check if there are any UBWs. It has been checked and you are satisfied that you haven't got UBWs. If somebody advises you that there are UBWs and you still acquire the property, then when the government asks you about that, you can't say that you don't have any liabilities. I think it is but right for you to remove it upon receiving the removal order, and you have to become liable. You knowingly acquired it. You get somebody to check it, and you know that there is a UBW. In this case, we may start a prosecution. Sorry, the speaker is off mic. If the UBW is already there when I acquired the property, so all I have to do upon amendment of the ordinance, I only have to remove it and don't have to bear the $2 million fine. Of course, you have to demolish it as to whether there are other additional liabilities. Well, in fact, there is a current provision here. Knowingly, or if we have reasonable suspicion that the owner is involved, then we'll deal with it. But if the owner can prove that he has got nothing to do with it, all you have to do is to remove it. Mrs. Regina Yip, in principle, I support the proposals, in particular, rationalizing the minor UBWs. Secretary, the number is huge. As of October this year, 36,000 notices have not yet been complied with in relation to the removal orders. Am I right about the numbers? There is the number of minor UBWs that have to be rationalized. Secretary.
你計呢
For UBWs, 38,000 removal orders have not been complied with, but 2,000 of them have not reached the deadline. So we're talking about 36,000 removal orders of UBWs that have not been complied with. Now, how many of them will be relevant to the minor works mechanism that we are going to introduce? We need time to conduct an analysis because of the huge number. In due course, we hope to be able to report to members on the breakdown. But at this moment, we're unable to give you this information. Now, because of the huge number of cases, the Buildings Department will or will not be applying for additional manpower, or would it be absorbed by existing resources? We have not completed the analysis, but we do envisage a large number of works falling under the so-called minor works in the future. In the future, we're going to consolidate the validation schemes, and registered professionals from the private sector will help the Buildings Department by validating the UBWs that are deemed safe. Well, we fully appreciate the need to control expenditure. It's a joint responsibility. So despite introducing the proposals, we won't aim at increasing manpower. Well, depending on the outcome of the public consultation, we will make use of existing resources to handle these matters in a targeted manner. Right, but it takes manpower to process all the cases. Public resources are involved. Will you adopt a user pay principle to recover costs since you're going to conduct inspections, etc.? Recovering the cost by charging a fee is reasonable. It will also be beneficial for owners as well, because if it's validated by the department, that means they won't be the subject of enforcement action in the future. Now, UBWs are the target of enforcement action, so it's rare for the government to charge the offenders as well. But we do recover the cost through fees for other areas, such as default works mechanism. If owners are unable to carry out the building works, the government will step in, and then we will charge a fee, and on top of that, there will be a surcharge as well in order to recover the cost. So perhaps under the default works mechanism, we could consider increasing the level of surcharge. We keep all options open. Mr. Tony Zay, I support the amendments, and I'm particularly concerned about UBWs. This is a long-standing problem, and the current approach of handling has not been effective, so I support the amendments. First and foremost, I think that we should minimize newly built UBWs. It takes time to clear the backlog, and I fully appreciate that. But for new building works involving unauthorized building structure, now, as your PowerPoint suggests, a new offense of aiding will be introduced. Of course, this involves only serious unauthorized building works. Now, the government should explain this new offense well, because this will certainly cause cause alarm among owners because they may not have the knowledge. Now you explain that professionals will be engaged. They will deliver reports on whether UBWs exist. You also refer to the new owner's liability. Still, you need to articulate the new policy well. What is meant by aiding an offense? Now, it may be easier for the purchase of a single unit, but in other cases, such as the purchase of a whole block of building, office properties, or flats with unique or special characteristics, you need to explain what you mean by unauthorized building works well. Because there will be problems. For example, owners will shun the responsibility as a member of the OC, and especially since the maximum penalty is quite serious, an imprisonment of 2 years. So you need to explain this bit well to avoid anybody being caught inadvertently by the law. Secretary. We propose that after a certain date, after the law has come into effect, if an owner buys a property with the help of, say, a real estate agent or lawyer, and if the property is found to have unauthorized building works, basically will provide for the following. The owner and the professionals assisting the purchase of this property by the owner in the process may be liable, because we do have reason to believe that they are in the know. They may even persuade the owner to buy this property with unauthorized building works. So these professionals must have knowledge of the existence of the UBWs. Now, we are going to promulgate guidelines for owners. For example, we'll advise new owners to approach certain professionals to check the new flat. And for lawyers and other professionals, likewise, the guidelines will provide that they should act in a certain way to help the owners. Now, if you advise the client to just go ahead and make the purchase despite checking for UBWs and despite the existence of the guidelines, then they'll be in trouble. Mr. Kenneth Lau. The government is going to tighten the regime under the Buildings Ordinance Cap 123. Now, in the new territories, many village houses are 4 stories high. They are built on the block ground lease, and then you have the government lot, new grant lot, and building licenses. So you have different mechanisms without any restriction on building height. Some small houses started with just 2 stories. They added the 3rd story and so on later. Because of the historical reason, the government did not put a stop to it. The proposed amendments seek to tackle serious unauthorized building works. But not all UBWs are visible. There may be unauthorized basements that are not visible. So in the end, the government is going to only go after new territories village houses. So my question is this: will the government take a different approach to small houses? Some village houses have multiple stories, as high as 4 stories, and the department has taken some of these cases to court. And even after 2 rounds of prosecutions, these residents are still reluctant to take the additional stories down. So will the government consider allowing the existence of these houses? Well, the member has rightly explained that because of the historical reason, we have taken a very different approach to anti-village houses, and that's the one-off reporting scheme in 2012. The scheme was suspended later. Now that's because of the unique environment in the new territories, and the rural environment is unique in the sense that if something falls off from the unauthorized building works, the consequence might not be as dire as the same case that happens in the urban area. And that is why we introduced the reporting scheme in 2011, and that no enforcement action would be taken for the time being. But we've also made it very clear that we don't tolerate additional stories on small houses. We're definitely not backpedaling. We're not going to further relax the criteria to accommodate these special cases, because if we do that, definitely we're seeing a great departure from the equality treatment between rural and urban UBWs, and we find the current proposal a pragmatic one. So we are going to relaunch the reporting scheme with the same criteria. No follow-up question, Mr. Kenneth Lau. Mr. Lemon Kwong. I support the directions of the proposed amendments. They will be put up for public consultation. The proposed amendments will help the government focus resources on tackling serious cases. It will also strike a balance between facilitating people's day-to-day living and tackling serious UBWs. Now, the government will also welcome suggestions on improving the proposed amendments. I'm concerned about buildings erected in the 1950s and 60s. That is, the developer might sold units to individual owners that are different from what's set out in the building plans. For example, some balconies might have been enclosed, and then there might be additional railing and canopies, so on and so forth, to increase the value of the property. Now, after the government has taken enforcement action, orders have been issued, and many owners are concerned. These owners are anxious as to whether the UBWs will meet the eligibility criteria for validation in the future, or when they should engage a professional to check and validate the UBWs. So I want to know whether priorities will be accorded before and after the legislative amendments. The other question is about statistics. Do you have these statistics to help us learn the priorities? Do you have statistics to show us what are the priority areas? Because some owners are also victims. I won't say they're cheated, but we want to make sure that they won't become victims.
Yeah.
Secretary, there are two specific suggestions here. First of all, we are saying that for relatively minor UBWs, we're going to provide a way out. In other words, you can have it validated. Well, the administration has already suggested that for things like drying racks and canopies, we do provide for a validation period. Well, some of them are already subject to enforcement. Are we going to sort of put it on the whole? I think this is a pragmatic suggestion. So perhaps we can ask the buildings department to slow down the process. But of course, if a minor UBW is posing a hazard, then it will be treated differently. In our paper, we have specific proposals. That is what will be covered by the minor works. Just now, the member said that perhaps when the building was constructed, there was a case of a number of UBWs en masse, and probably it was carried out by the developer. Can we sort of treat it leniently? We do have an open mind, but then for the time being, in our paper, we haven't covered such. On the face of it, it may not be minor in nature, but it may be sort of it may be of a different nature. Say, for example, a balcony that has to be enclosed. We are having a 2-month public consultation exercise. Perhaps we can benefit from hearing from the community. Mr. Chen Hempen, I know the compliance rate is low. In relation to MBIS, just 41%, because for MBIS it is usually followed up by a major renovation exercise. Owners have to face different challenges, so it is quite a difficult task. For 30-year-old buildings, they are still of good quality. I'm referring to the case in Hong Kong. For buildings built much earlier, the quality might not be as good. But then for buildings constructed in the past 30 years, I believe that they're of good quality. So since the compliance rate is low, would you be more interested in focusing on the older and more dilapidated buildings so that you prioritize your work and then you can enhance the compliance rate? The second question is about introducing a new offense. That is, aiding an offense is tantamount to committing an offense. Estate agents and solicitors involved in the property transaction. A solicitor may not actually visit the site, and the solicitor may not be in a position to tell whether there are UBWs. If you need to get professionals to check, then it is going to add to the cost of the property transaction. So is the government trying to impose a requirement that is you must have your building inspected before you can go ahead with your property transaction? Or do you have other suggestions? If the relevant professionals may become liable, then the owner will be asked to do more, and then that would only add to the cost of acquiring a property. So please elaborate on how you plan to go ahead with this. And then for tenement buildings, you may not be able to check the conditions of your building against the building plan. And I want to know whether that means that no one would dare to have any property transactions and then the properties cannot be sold. Another point is about relaunching the one-off reporting scheme for village houses in the new territories. I think it is a very pragmatic proposal. For owners who missed the last round of reporting, they will be given a new chance. And then the existing UBWs can be registered. But then that leads to a question. There are squatters in the new territories such structures may be demolished whenever they become sort of vulnerable. I want to know whether you're going to cover the squatters as well. 3 questions from me. Secretary, the member asked as to how we are going to issue an inspection notice. We don't have it issued automatically whenever a building reaches the age of 30 years, because we know that the volume is huge. Now, the law does says that when the building has a history of 30 years or more, then it can be caught by the scheme. But if the conditions are good, then we don't need to do so. The Buildings Department will select the buildings every year. Currently, about 600 per year, depending on not just the age of the building, but also the conditions of the building and the safety aspect of the building before notices of inspection are issued. Now, in future, owners are advised to be cautious. We're not imposing a duty on the owner to engage professionals to inspect the building. Say, for example, if you're acquiring a new property, there's no need for that. But of course, owners have to strike a balance. I think if you have to pay for the professionals' services, I think you're merely discharging your duty and you have to pay for that. And then when I was the Director of Lands, it was in the year 2016, there was a scheme that is after a particular year, if you are going to expand your squatter, then you have to demolish the entire structure. But then for other squatters, you do allow them to be re-erected or reinstated. Ms. Doreen Kong, a few questions. Thank you, Chair. First, professionals aiding owners acquiring properties with UBWs. Well, a few years ago, I received quite a large number of inquiries from our colleagues in the legal sector, especially those involved in property transaction. When they read this paper, they became anxious. They were of the view that on many occasions, when they assist owners or when they assist vendors in buying the properties, there's no way that they know that there might be UBWs. Say, for example, properties with a rental agreement or properties sold in an auction. The vendor himself might not have seen the property. Now, in your paper, the Secretary talks about knowingly aiding the owner, but knowingly is quite a tricky word. So our legal professionals are worried that the government may try to instigate a prosecution first, and then it is up to the professional to prove that he or she hasn't got the knowledge. So I want to reflect to you the anxiety on the part of our colleagues. I have to declare interest. I'm also involved in property transactions. Now I come to my second point for these minor UBWs. I welcome the idea that you're going to allow people to get off it. But then I do have a question here. For minor UBWs, you're going to enlarge the scope. There will be more categories. Are we going to get the following scenario? That is, a single property may have got quite a few UBWs, and cumulatively, they become a major or a series UBWs, or over a period of time, different UBWs are introduced. I want to know whether it would become out of control at the end of the day. Secretary, first of all, legal professionals involved in property transactions, and they're worried that they might break the law inadvertently. We need to explain the issue here. Now, in future, usually a lawyer will check with the land registry as to whether an encumbrance has been entered. That is, whether a UBW has been registered. Now, if that is the case, and yet the lawyer still advises the owner to acquire the property, then they will be our targets. But then if there's no encumbrance shown on the register of the land registry, then the lawyer himself cannot tell and would not know that there are UBWs. We don't expect that from the lawyer. The lawyer only has to remind the owner to get a professional to check the property for UBWs. Of course, in future, there will be protocols or guidelines to be issued for different professionals to understand what is expected of them under the amended ordinance, and in what circumstances will they be liability free. We won't abuse it. We are targeting those who know that there are already encumbrances and still advise the owner to acquire the properties. For minor UBWs, for a single property, will there be more and more of them? Well, for drying racks and supporting frames for air conditioners, I think you will only erect a limited number of them. But for commercial buildings, will there be so many signboards that they get out of control? Well, of course, you have a very good idea, and we'll try to refer this to the department to make sure that it's under control. Mr. Frankie Yik, well, Tony Che, Chan Hang Ban, and Doreen Kong already asked my question. Well, taking the secretary's replies together, can I say that I understand it in this way? I acquire a second-hand property. I don't want to break the law. I get a professional to check whether there are UBWs against the building plan. And then I get the answer, and then I will check. And I'll decide whether I still acquire the property. Now, for the case of lawyers, unless the land registry shows an encumbrance, the lawyer should not be made liable. If that is clear, then it means that in future, if you want to acquire second-hand property, you will certainly attract an additional cost because you don't want to breach the law inadvertently. That is bound to happen. Is my understanding right? This is also part of our proposals. And we will mainly be talking to the Institute of Surveyors as to how we can carry this out. Of course, there is a cost element. We don't want to unnecessarily add to the burden of property transaction. But we do believe that it is a good idea to have it carried out properly. It will be a good practice. Frankie Yik, I in principle support the proposals. Mr. Yang Wen-kit. Basically, I agree with the proposed amendments to Cap 1, 2, 3, but still I've got a number of concerns. First of all, for the notices under the MBIS and MWIS, the compliance rates are 41% and 70% respectively. I don't think you're going to resolve the problem for MBIS notices, just like in the case of the fire safety notices under Cap 572 for 3 new buildings or for dorm or non-active OCs. I don't think they can really do anything about the notices, even though you have issued notices. Just now, the secretary said that the amendments will encourage the owners to comply with the orders. I had this experience of a tenement building. They're supposed to have 5 persons to form an OC, but only 3 are interested, so they can't organize themselves into an OC. Now, you say that by having OC, you can deal with the notices under Cap 1, 2, 3. If an owner is not willing to become a member of the OC, will he be regarded as obstructing the way or not being cooperative? Now, a $3,000 fine under the fixed penalty ticket. Now, old ladies were complaining to us that they have been cheated. Now, for owners receiving MBIS and MWIS notices. They know nothing and they have been cheated. Not that they don't want to do it, but then sometimes they're not able to comply with the notice. They get a fine of $3,000, and yet they don't really have to pay that much for the windows to be checked. So please provide support to the owners' corporations. MBIS, MWIS are important. You need to have a dedicated team to answer the inquiries of the owners. The FSD has got something similar, but not so in the case of the BD. You should learn from the FSD.
The next point is about the definition of serious UBWs. We've seen unauthorized structures such as swimming pools and illegal basements. Of course, we should take enforcement action against these serious UBWs. But in my community, we also have, say, illegal structure on the rooftop. It may pose a serious consequence of blocking the emergency escape. But according to CAP 572, an encumbrance will be imposed because of the UBW. Now, how are you going to tackle these UBWs in the common parts of the building? Please be brief, Mr. Yang. Well, I don't need an answer from the Secretary. I just want to finish what I have to say. No, give time for the Secretary to respond to your point while I ask for a written reply. I just want to make this comment. For UBWs in common parts of the building, I don't think you should impose an encumbrance to stop property transactions. Now, what is the government's objective? Is it that property transactions should not be carried out according to CAP 572 or CAP 123? What's the rationale? I don't think Secretary can give you a very short answer. About support for building owners. Now, you said that the Buildings Department does not support owners. Well, that's not true. For buildings management and maintenance, support is provided via the Urban Renewal Authority. But of course, we can always step up our effort. The Development Bureau has this platform. We take a targeted approach. Whenever we have major operations, we explain our action to building owners. Now, about illegal structure on rooftops, which are serious, we'll continue to take enforcement action in the future. The purpose of taking enforcement action is to remove the UBWs. Our objective is not to stop property transactions. Our objective is to remove illegal structures and to tackle non-compliance. Right, the last member to speak, Mr. Louis Long. Thank you, Chair. The Buildings Ordinance is enacted to ensure building safety and to make sure that building works are carried out safely. So I support the amendments to the Buildings Ordinance. I have a number of questions. First, about serious UBWs. Do you have a rough estimate, say, about the serious UBWs in the buildings in Hong Kong? Do you have any idea whether and how much resources are needed to tackle the UBWs? Now, I'm from the property sector. My next question is this, and this is really my area of concern. That's part 2 of the ordinance relating to building control. The government has introduced streamlined procedures. Do you have a timetable of review of part 2? Secretary, to take the first question, whether we have an estimate for the number of serious UBWs in Hong Kong. Now, for UBWs which are subject of removal orders, I answered Mrs. Regina Ip's question just now. 36,000 removal orders have not been complied with, but we need to give you a breakdown, and it takes time as to what amounts to minor UBWs that have not been removed. A territory-wide survey may be needed, but we don't have the resources to do that at this moment. But after completing the analysis on the 36,000 cases, we may be able to have a better idea. The analysis will help the Buildings Department take a more focused approach and a more pragmatic approach against UBWs. Now, I don't know whether the member is referring to professionals about rationalizing this policy. No, Chairman. What I mean is for Part 2 of the Buildings Ordinance relating to the submission of building plans and the relevant procedures, I want to know if and when the government will conduct a review. Right, this is about something else. About streamlining the procedures for building plan submission. In fact, we've introduced simplified procedures to expedite the workflow. The next stage is the works stage, and at various points, approval from the Buildings Authority may be needed, and we are in the process of conducting a review, and the outcome should be ready by next year. That completes the discussion of this item. Members who spoke on this item gave different views. They also put some questions to the administration. I think that the questions will help the government in the consultation process. I'm sure that the government will carefully consider these comments. Next item, agenda item 3, Capital Works Reserve Fund block allocations for 2025-2026. This is a funding proposal. So let me remind members that according to Rule 83A of the Rules of Procedure, please disclose the nature of the interest if there is any direct or indirect pecuniary interest in relation to the item being discussed. Now, if you want to speak, please press the request to speak button now. Let me welcome the administration to our meeting. Thank you, Chair. In the interest of time, I will skip the opening remarks. We have 24 representatives from 25 government departments. They are here to answer members' questions. I urge members to support us in submitting this item to the PWSC at the meeting of the 22nd of January. 3 members have pressed the button. They will be speaking. They include Mr. Michael Tian, Mr. Gary Zhang, and Mrs. Regina Ip. 3 members would like to speak for the time being. I'll give each member 4 minutes, questions and answers. Mr. Michael Tian, please. Thank you, Chair. I'd like to ask about the ongoing items. Number 1, the investigation and preliminary design for the Tuen Mun Road. The estimate is $50 million. Next year, you've set aside $10 million as the estimate. I've been following up on the Tuen Mun bypass for many years. And about the ventilation building, I've received complaints from many residents because you're going to do away with half of the mountain. So imagine the lorry trips. I've looked at different examples around the world. In Taiwan, there's a 9-kilometer road, and in Taiwan, there's a 13-kilometer tunnel. They don't need a big ventilation building. They just need ventilation shafts. So no major works are required. Instead, we have a 7.5-kilometer bypass. And because of that, we are going to erect a major ventilation building there. Now, I've asked the experts of these two tunnels to assess whether it's necessary to build this ventilation facility in Tuen Mun here, because it's just 7.5 kilometers long, and if we step up ventilation at both openings, in theory we should be able to provide good ventilation. And in that case, we just need another consultancy, a third-party consultancy study. Now, I just want to know whether you are minded to take my suggestion and whether the $10 million estimate includes what I've just said. I'll give the floor to my colleague. Thank you for your questions. Now, I can tell you categorically that the $10 million include engaging a third-party consultant to conduct an independent assessment. They will look at both the design of the bypass in Tuen Mun as well as the ventilation building. And I'm grateful to the member because in the previous consultation process, we listened to the views of stakeholders, and we are going to engage overseas or non-local expert to conduct an independent assessment on our proposed design. So we'll look at areas of improvements of the design as well as the ventilation building. Well, would you engage one of the consultants that I mentioned? Yes, we'll consider that. We will be engaging some well-renowned experts who are familiar with the technical design of other facilities in different places, and we'll also consider the experts that Mr. Michael Tian mentioned, who's in charge of the project in Australia and in Taiwan. If you need a telephone number, I can pass it on to you. Mr. Gary Zhang, I have a question on head 705 and 105 DX. I see that the $70 million will be involved, and this is a scale back. I understand that the reduction has to do with reduction in cash flow requirement. Well, I find it quite astonishing that you're able to save $70 million for a project at its construction stage. So can you explain why? Next question, head 707 Newtown Development 7100CX. I remember back then the SFST told us at the previous meeting that they would definitely not accept departments truncating the projects, breaking the projects down into different bits so that each project would entail a cost of less than $50 million in order to get the approval. Now, I find the following quite suspicious, such as the connecting road from Hong Kong West to Khao Yi Chau, and also another connecting road from the Lantau Link to Hong Kong to Khao Yi Chau. While we said categorically that there would be a cross-harbour road as well as railway, and that these two should come as one project, but now I see two different items. Now the other is about Ngau Tam Mei. $32 million for the detailed study as well site formation and infrastructure works. The design also entails a cost of $32 million. So They belong to site formation and infrastructure works for Old Town, May, New Town. Why are they broken down into two separate projects? I'd like the administration to explain that to me. Deputy Secretary. I will invite the EPD to take the first question and the CEDD to take the second question. I'll take this question on subhead 5101DX. $70 million estimate has to do with some recycling facilities such as a green station in Wong Tai Sin. The construction is due for completion, and at the same time we are looking for new locations for installing the green community stations, and that accounts for reduction in the estimate. We also have the refuse transfer stations such as the one in Chung Kwan O Area 132. It was supposed to commence earlier, but because of the location, we consulted the district council before we commenced work, and that accounts for reduction of the estimate as well.
The next one, the TD. If I may add to the answer, our usual practice is that in the light of the scale, location, as well as the schedule, then we will decide on whether to split a project into a few. Now, regarding the one referred to by the member, it is of a large scale. And then we have got the main road, we have the sewage, waterworks, etc. It's hugely complex, so we're going to phase the project, and therefore we have got a few individual or an independent items so as to launch the project. As to the detailed project design, we have the Hong Kong Island West Kau Yi Chau Link as well as the North East Lantau Kau Yi Chau Link. First of all, for the first one, Island West and Kau Yi Chau Link, and it is going to connect the fourth Cross Harbour Tunnel with Kau Yi Chau. It's a 5 km long tunnel, and then for North East Lantau Kau Yi Chau Link, it is going to be a bridge. So we're going to connect with the Lantau Link, Bridge 11, as well as the Cheng Yi Link. So it is going to consolidate the status of Lantau. It is going to be a 3 km long bridge spanning over the waters. So the nature is different. And then for the timing, again, it is different. For the bridge, generally speaking, it will require less time than building a tunnel. So for the two links, we'll also have them completed at different in the different sort of time scales, so they should be regarded as independent projects. In the case of Old Town May, again, we have to look at the location. We have them planned separately. Say, for example, we have the university town as well as the third hospital and medical school. We'll have the infrastructure first, and then we will carry out the infrastructure works first as well as the support facilities, and therefore we have split the project into a few smaller items because they're subject to different schedules. Thank you. Next, Mrs. Regina Yip. First of all, let me share my comment regarding the artificial islands. You have the idea of a double gateway. For a person living on the Hong Kong Island, I have great reservations. Transport is very accessible. I don't think we need to have a separate link. For the Hong Kong Island, again, the area is small. It is easy to have traffic congestion. I don't see any gain from transporting more people to the Hong Kong Island. Now I come to my questions. For part E, that's about resumption of land. And then at Tongji, you're going to reprovision the facility of the education university. Is that about the works, or is it about the land resumption costs? Well, perhaps I can defer to the Lands Department because it is about land resumption. Thank you, Chair. Under Head 701, that's about land resumption costs. Yes, land resumption costs. Well, in that case, for the year 25-26, you're going to spend a small amount of money. Is it because the process is slow? I suppose you would resume land in one go. Why is it so? Other than land resumption costs, we have also got to provide for the ex gratia allowance. So upon resumption of land, we have to tie in with the work schedule. So land resumption as well as ex gratia allowance, right? Follow up. But still, to me, the pace is slow. I think you should expedite it. You have already reserved a large amount of money, and yet the amount of ex gratia to be paid out will be small. In other words, you are going to act very slowly. And then for 110CA, I have 1100CA. I've also got another question, or it should be something else. I'm sorry about that. Page 23 of the Chinese version, item 145, Central Wan Chai bypass, as well as the connection with the Island Eastern Corridor. In the year 25-26, there will still be a lot of work to be carried out. I thought the community would think that the work has been completed. How come that there's still outstanding work, Mr. Chung? Well, for the Central Wan Chai bypass, basically it has been completed. What is left behind is the remaining contractual arrangements with the contractors. Sorry, I can't quite catch you. Please speak closer to the microphone. Yes, Chair. I thank the member for her question. For Central Wan Chai bypass, it has been completed to a very large extent. What is outstanding is certain contractual arrangements. We need to sort that out with the contractor, so the provision is for that purpose only. Any follow-up questions? Well, I've also got a question about the boardwalk, but I cannot locate it. But I don't want to hold the meeting. I can ask the question later. Yes, maybe you can follow this up after the meeting. Next, Mr. Yu Park Leung, but then before he speaks, I have to draw a line. We need to reserve time to deal with the funding request today. So Mr. Yu, followed by Wendy Hong and Gary Zhang, and he would like to speak for a second time. Probably I can allow him to do so. If there aren't other members wishing to ask questions, well, Mrs. Yip would like to ask a second question. Yes, I do allow for a second round, but for a shorter period of time. Mr. Yu, two items. First of all, page 10, and that's in relation to Cat D of the Public Works Program, refurbishment of government buildings. So head 703, subhead 3004 jigs, proposed new items. You talk about the refurbishment of baggage hall at ground floor, toilets and VIP lounge at second floor, and North Podium Garden in Kai Tak Cruise Terminal. It is a Cat D work. Of course, everybody is concerned about the Kai Tak Cruise Terminal. It is to be for the sake of the tourists, and the cruise terminal is in operation, and we are going to get more and more cruises calling at our port. Cat D, does it mean that we are only going to get it at a very, very late stage? It seems the priority is low. And then another proposed new item, and that's in relation to the enhancement of the Ting Kau Beach. Today, I have a written question to urge the LCSD to put in new ideas in the operation of our swimming beaches. So please elaborate on the content of this particular item. So 2 questions. So first of all, Mr. Chen from the ASD. I would like to thank the chair as well as Mr. Yu. Well, first of all, refurbishment of baggage hall at the ground floor, toilets and VIP lounge at the second floor. Well, in fact, in the year 2023, we know that from the policy address, we're supposed to develop the tourism industry. So we'll refurbish the baggage hall on the ground floor. We'd like to upgrade the flooring as well as the lighting. There will be over 10 toilets that will be refurbished, like the ceiling, the lighting, as well as the facilities there. And again, ceilings, lighting, ventilation, etc. will be carried out at the VIP lounge. Mr. Yu, you don't have to worry. It will be commenced in June 2025 to be completed in June 2026. So we are going to tie in with the request of the Tourism Commission. Well, make sure that you carry out the work when we have fewer cruises calling at the terminal. We will follow strictly with the requirements of the Tourism Commission, and we will tie in with the requests of the operator there. Another question to be answered by ASD as well. Yes, Mr. Chen. Yes, in relation to Tinkau Beach in Chunwan, we'd like to enhance it, and this is part of the enhancement projects of the LCSD. Well, we want to follow the safety requirements. We will carry out a study to see whether the request is necessary, and then we will set out the priorities. In October 2026, it will be started to be completed in September 2027. So we're going to demolish existing facilities, and then we will have pumping stations, the watching towers, offices, stores, etc. And we'll have a accessible toilet so as to enhance the facilities there. So we'll tie in with the needs of the users of the LCSD. Thank you. Before Ms. Hong speaks, I will extend the meeting time. We have to finish by 10:45 since we have got the sitting of the electrical. I don't think we need to go that far, in fact, Ms. Hong. Basically, I support the block allocations for the coming year under the CWRF. Some questions here. Well, head 701-1004CA will see a huge increase, almost 60% more. So can the administration tell us the following? Why do you have to increase it by 60%? What are the major items to be covered? And then head 701. A007GX computerization. Again, you need to increase it by $390 million. So there will be $2.52 billion in total, so an increase of 18.3%. It is important to have computerization projects, but what are the criteria? Do you have any sort of mechanism to decide on the priorities? I think you have set out certain items, but I don't think they are urgent, like animal welfare case inquiry system under the AFCD. Since we have got a huge budget deficit, I just wonder things like that can be put off for a while. Well, in fact, they will be discussing greater details at the relevant panel meetings. Maybe we can get a brief reply from the administration. I would like to thank Ms. Hong for Dr. Hong for her questions. The first one is about the lands department. For the second question, that's computerization. We haven't got anybody from the digital policy office because the relevant panel had already discussed that. We'll refer Dr. Hong's question to that office, and then Dr. Hong can get further information at the PWSC meeting. Yes, Lands Department, 1004CA. $157 million will be needed when compared with $58 million previously, an increase of 58%. This is because for land resumption, it is believed that in the year 25-26, money will be dispersed, and then there will be a need to pay out ex gratia allowance. So we expect a huge increase in the coming year.
Dr. Wendy Hong, any follow-up question? Mr. Gary Jiang for the second round, 3 minutes. Thank you, Chairman, for giving me this opportunity to put my question again. I want to say that first and foremost, I support the funding allocation. Despite the fiscal position, we need to go ahead with some of the projects. Now, picking up on my last question, Chairman, of course, you're experienced. In 2022, the development panel discussed a paper, that's CB bracket 21930/2022, and it says categorically that this is Hong Kong Island West connecting road to the Northeast Lantau link. So these are two different projects. Go back and check the previous document that submitted by the administration. This is not how you phrase it. You are now breaking the project down into two so that each project doesn't go beyond $50 million and that you don't need to apply for approval with the PWSC. Now, you mentioned the works involved, a bridge and a tunnel. Now, this is not how it works. I am very serious about it. I will go back and check whether there are similar projects. You should submit the project to PWSC for funding approval. I don't accept the reason that you gave. Yes, CDD. Mr. Ma. To answer Mr. Zhang's question, there are two sections of the connecting road that they have different structures. Now, Mr. Zhang asked for other examples in the past. Let's say for Route 6, we had the Trunk 10 Bridge and also the Trunk Road T2, as well as the tunnel. So there are three different sections. Now for this project involving a connecting road, this is for site formation and preliminary advanced design and ground investigation. Now we will provide details to explain how these projects, the integrity of the whole project. Next, Mrs. Regina Ip, second round, 3 minutes. Page 18, about the Wan Chai Development Program. Can you tell us more what this project is about? I see that despite a huge allocation, not much work has been done. It's done in drips and drabs. I didn't catch it very clearly. Please speak into the mic. Page 18. Wan Chai Development Project Phase 2. In 2024-25, $20 million were spent. In 25-26, no estimate set aside. Does it mean that the project has been completed? What is it about? Wan Chai Development Phase 2. Right, Wan Chai Development Phase 2. Well, I think this relates to land acquisition. I will invite my colleague to take this question, Ms. Lang. This is in under head 701 about compensation. Now, works were carried out back then. Compensation could not be made out at the time because we needed the consent of the affected persons to accept the amount. So as the member put it, in 2024-25, this amount was set aside. In 2025-26, since we estimate that the whole process will have been concluded, we have not set aside any allocation. And then page 20. Item 124, roadworks on the boardwalk underneath Island Eastern Corridor. Now, the boardwalk is really a popular project, but then it's been dragged on for years. Can you speed it up? It seems that you're doing it in drips and drabs. Right, about the boardwalk underneath the IEC. Thank you, Chairman. Thank you, Mrs. Yip, for the question. We are working full steam in relation to this boardwalk project. For phase 1, starting from the eastern part, in the coming 2 months, it will be completed, and that's for phase 1. For phase 2, it is expected to be completed by early next year, and by then the boardwalk will be commissioned, and that the public will be able to enjoy a walk on the boardwalk from east to west, and enjoy the waterfront promenade. Oh, I see that time is up. Just a follow-up question. It's a general question. Some projects take a long time to complete. The Works Department may decide to carry out the works in phases. Now, this stretches the whole period. One example is the facelift in Mui Wo. This project has been dragged on for 20 years. If you have a policy dedicated to, say, promoting tourism, you should not drag on your feet. You should allow the Policy Bureau to make the decision, not the Works Department. I think Mrs. Ip's viewpoint is echoed by many, and that sometimes projects are dragged on for too long. I think the government is conducting a review in relation to the high project cost and the stretched project timetable. And we even have a subcommittee on this matter. We do hope that this review can drive an improvement so as to drive down construction costs and avoid unnecessary delay. Mrs. Regina Ip asked a general question. She didn't raise a question in relation to a particular project. So this is just a general observation. Please note your comment. All members who'd like to speak have spoken. I haven't heard any objection of the paper being submitted to the Public Works Subcommittee. So that's the end of this item. I thank the administration for coming. Oh, I'm sorry. I need to ask whether members agree with... Right, Mr. Michael Tan, did you raise your hand? Did you want to declare interest? Sorry, I still have a question. I'm sorry, I've declared that the discussion has ended. Please follow up on other avenues. We move on to the next item, AOB. This is the last meeting of the panel in the 2024 legislative session. This panel held altogether 11 meetings in this session, and I sincerely thank members and the administration for participating in the panel's meetings. And at today's council meeting, I will submit a report to the President to report on the work of the panel in this session. So I'll be doing that in a moment. So nothing else on the AOB. Meeting's adjourned.